On behalf of President Barbara Snyder and the Case Western Reserve University community, welcome to our 2010 annual Constitution Day program. I am Don Feek, Vice Provost for Undergraduate Education at Case Western Reserve. It is my honor to welcome our distinguished speakers, student panelists, and guests to this important day and event. Several years ago, the late Senator Robert Byrd of West Virginia, who is known for his fierce defense of the U.S. Constitution, sponsored language in a bill that requires all educational institutions that receive federal funds to hold an educational program related to the Constitution on the anniversary of its signing, September 17th. This is a special opportunity to remind ourselves of the principles under which our form of government was founded and its protection of freedoms that is envied throughout the world. This year's program was planned and organized by a group of undergraduate students led by Cheyenne Chambers and advised by Professor Laura Tartikoff from the Department of Political Science. I hope you'll agree that the subject of today's program, States Uprising, the Constitutionality of Healthcare Reform, is timely and relevant. The enactment of the legislation has resulted in a strong reaction from both the public and the political left and right. It is a policy issue that continues to be debated and will have significant influence in determining the outcomes of many November elections. Today we are privileged to have Ohio Attorney General Richard Cordray and Indiana Solicitor General Thomas Fisher with us to present and discuss their state's respective position on the constitutionality of the legislation. Thank you both for being here to address this important issue. We look forward to a thought-provoking and informative discussion. They will be introduced later informally by Mr. Griffith. In closing, I would like to ask the Student Planning Committee and Professor Tartikoff to stand and be recognized for their fine work in organizing this year's Constitution Day program. Please stand. Thank you all for coming.
Thank you, Vice Provost Feek. Good afternoon, ladies and gentlemen. My name is Daniel Griffith, and I'm the Master of Ceremonies. Distinguished guests, faculty, students, and friends. The purpose of today's forum is to celebrate the 223rd anniversary of this country's founding charter, the Constitution. With that said, it is an honor to introduce Ohio Attorney General Richard Cordray, as well as Indiana Solicitor General Thomas Fisher. The Undergraduate Student Constitution Day Committee appreciates your taking the time to discuss the constitutionality of healthcare reform law and to answer some of our questions. I would also like to introduce the three panelists, Ms. Lauren Geiser, Mr. Michael Iannitti, and Mr. Brandon Mordew, as well as the moderator, Ms. Cheyenne Chambers. Thank you.
Ladies and gentlemen, the Patient Protection and Affordable Care Act of 2010, hereby referred to as the Affordable Care Act, is the most comprehensive federal health care reform in American history. The Senate approved of the bill on Christmas Eve last year on a 60-40 party line vote. The law mandates that all Americans buy health insurance or pay a fine. Despite Congress's aiming to improve the quality and delivery of the healthcare system, this law is not without controversy. One source of the constitutional challenge, brought by more than 20 states, is that the individual mandate exceeds the enumerated powers granted to Congress under Article 1. Moreover, the states contend that it violates the Commerce Clause and the 10th Amendment. Mr. Fisher, you are one of the challengers. The floor is now yours. You have 15 minutes, and so will Mr. Cordray. Mr. Fisher.
Thank you, Ms. Chambers. Thank you for having me today. I've been looking forward to this for several weeks now, and the idea of celebrating Constitution Day by debating what the Constitution means is, of course, entirely appropriate, not to mention required by federal law. By way of background, my state, Indiana, is a plaintiff state in the Florida action that is challenging several components of the Affordable Health Care Act. We are not alone. Certainly there are 20. It is led by Florida, by and large, with the help of lawyers from Washington, D.C., who have spent a fair amount of time thinking about this act. And all the states are contributing in their own way. And certainly there's a robust debate of ideas that goes into litigation such as that. But I think where we all unite on the plaintiff side of that case is in the idea that there has to be a limit to federal government power. And we begin, I think, thinking about that when we begin thinking about the individual mandate. Now, I want to, for one moment, focus you on the part of the Constitution that's really at issue here. When we think about the Constitution and how it preserves liberty, it is tempting to think about the Bill of Rights, especially the First Amendment. More recently, in light of Supreme Court decisions, the Second Amendment. Certainly the Fourth Amendment. The Third Amendment, quartering of troops in houses during wartime or during peacetime, doesn't come up so much. But the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, all of these rights that we're used to that protect us from unreasonable searches and seizures, provide us right to counsel, provide us fair trials. These are all critical. But they, I submit, are secondary. What is primary is the division of power at the federal level by the founders of our country. The United States government, the Congress of the United States, is not a legislative body that has unlimited power. It has enumerated powers, and those limits are there for a purpose. They're there because the founders realized that the best way to preserve liberty was to divide government and to limit what it can do. States have what is known as the police power, the general power to be able to legislate for the good of the people, for the public welfare. When Congress legislates, it has to have a specific enumerated power. So the question becomes, what about this individual mandate? Beginning in 2014, anyone without coverage, without insurance coverage, must pay a penalty, up to $695 a year. I'm summarizing in a way because these things are graduated over a period of years, but for purposes of debate, it's $695 a year, up to a maximum of 3 times that amount per family. Now, this is the first time in history that Congress has required individuals to purchase a private sector product as a condition of living in the United States. Can Congress do this? The question invites not only the necessary textual, structural, and historical inquiries of constitutional law, but it also invites a broader debate. In an age where the prevailing mantra has been, yes, we can, do we and should we adhere to the notion that federal powers are limited? Now, the individual mandate brings this question into stark relief precisely because the implications on liberty are so obvious. The whole premise of the individual mandate is that many individuals need to be made to purchase health insurance against their will. But the whole premise of divided and limited government is to protect liberty. The Federalist structure, again, not the Bill of Rights, is the first line of defense to liberty. Now, I know where Indiana stands on this question. I know where my side of the debate will draw the line with respect to the individual mandate and where we see the limits of congressional power. Now, what I'm waiting to hear from the federal government, from those who advocate for the use of this kind of authority at the federal level, what I need to be listening, what we all need to be listening for today, is whether those defending the mandate believe in limited federal power, and if so, where the line is to be drawn if the individual mandate does not cross it. So the obvious question, what is the source of power behind the individual mandate? Well, the administration itself has changed its tune on this over the years. Originally, President Obama, about a year ago, in a television interview, refused to accept the argument that the mandate to buy health insurance was any kind of a tax. He, I think for obvious political reasons, did not want to be seen as imposing a tax on the American people, considering the usual reaction Americans have to taxation. The act itself cites the authority of Congress to enact the individual mandate as the power to regulate commerce among the several states. That, of course, comes from Article 1, Section 8, Clause 3 of the Constitution. The Congress power is a critical focal point of the debate today, and it has over the years become somewhat elasticized, candidly. The court has not always been rigid in its interpretation of the Commerce Authority. But the United States has not been content to rest on the Commerce power in its litigation positions. It now says that, in fact, the authority to impose the individual mandate comes not only from the Commerce power, but from the power to tax for the general welfare. All of these theories have serious shortcomings. The Commerce Clause is not an all-purpose grant of congressional police power over national affairs. The Supreme Court has held that Congress may regulate three categories of activity pursuant to its commerce power: the channels of commerce, the instrumentalities of commerce, and, what is most relevant here, the economic activities that substantially affect interstate commerce. The Act's findings make clear that Congress was intending this to fall into that third category, that this is something that substantially affects interstate commerce. Now, the overriding theory is that the widespread non-purchase of health insurance substantially affects interstate commerce because, through a series of assumptions and inferences relating to the way the healthcare system works and the usage of the healthcare system and the costs associated with the healthcare system, one could reasonably anticipate that universal purchase of healthcare insurance would yield the financial base necessary to fund insurance for everybody. In other words, that we have to make everybody purchase health insurance, otherwise we can't afford to buy it for everybody. But the lesson from the Supreme Court precedents on this issue, from most specifically the Lopez and Morrison cases of fairly recent vintage, past 15 years, is that such a logical inference upon inference connection between something that is not inherently economic and interstate commerce is not enough to trigger Commerce Clause authority. The Lopez case had to do with possession of a gun near a school. Could Congress prohibit possession of a gun near a school? The answer was no. Possession of a gun near a school is not an economic activity. It's not enough to build an inference upon an inference to say that economic activity must have led to the presence of the gun in someone's possession near the school. Morrison involved violence against women. Was the prohibition of violence against women, or was violence against women itself, an inherently economic activity? The answer was no. It is not inherently economic activity, even though one could pile inference upon inference and conclude that violence against women affects interstate commerce at some level. That was not enough. Now, in contrast, where the Supreme Court has permitted Congress a fairly broad range of authority, had to do with activities where there is an inherently economic component. Wickard v. Filburn, a classic case from the 1940s, upholding the Agricultural Adjustment Act and the wheat quotas that it imposed to a farmer who grew wheat for his own use only. The conclusion was, farming, especially wheat farming in particular, is inherently economic. More recently, Gonzalez v. Raich, the court upheld Congress's regulation of growing medical marijuana. Similar conclusion. Growing medical marijuana is an inherently economic activity. It is a commodity with a well-established market. It is economic on its own. Now, in the 60s, the Supreme Court upheld, or in the 60s and early 70s, the Supreme Court upheld the enactment of the Civil Rights Act and its regulation of local businesses under the use of the commerce power. Cases involving local motels and restaurants that have a minimum clientele of interstate travelers could be regulated under the Civil Rights Act, under the theory that, in fact, there is commerce. It is a business to run a motel. It is an economic activity to have a diner. And furthermore, there was necessarily going to be an interstate component based on the terms of the Act. But unlike each of the individuals involved in the cases where the court has upheld congressional authority, individuals who decide not to purchase health insurance are not willing participants in any kind of commercial activity. To the contrary, they have chosen to abstain from engaging in commercial activity. Now, it is incorrect, I think, to say that the individual mandate merely regulates the purchase of insurance or participation in the healthcare system. Its application is simply not triggered by those activities. Is illness an economic activity? Is that what's being regulated here? I think it's a bit of a stretch to say that this individual mandate regulates illness. One might plausibly argue that. But I think it's even more of a stretch to say that illness is inherently economic. Now, if we assume to the contrary, then what is the limiting principle? The limiting principles, of course, are not just of theoretical importance, but of doctrinal importance. If illness is inherently economic, then so too, of course, is wellness. And if illness and wellness are both inherently economic, what is possibly left that is not economic? The very state of being in America can be regulated. If the argument of those who defend the mandate is that there are no meaningful limits on congressional authority, well, then that should be the express proposition that we debate. But if the argument is that the Commerce Clause imposes limits, just not limits that have been breached here, then I think it is incumbent upon those defending the mandate to articulate precisely how we know that the mandate does not go too far. Now let me shift gears and talk for a few minutes about the tax authority. Even if the individual mandate is construed as a tax, that is, the penalty that is imposed for failing to purchase health insurance, is construed not as a regulatory penalty, but is in fact construed as a tax, which as an initial matter I think is not terribly plausible, then it can only be understood as a direct tax, a direct capitation, and that as such it is in violation of the constitutional requirement that direct taxes on individuals and property be apportioned by state based on the most recent census. That is a textual requirement from the U.S. Constitution in Article 1, Sections 2 and 9. Now the point of the apportionment requirement was to make sure that the per-person impact of any particular direct tax would be the same in each state, though it might vary within a state, so that states with more people, more land, etc., could not impose a disproportionate tax on those who had fewer people or less land. In contrast to taxes on the manufacture, sale, or use of a commodity, or license, or property, the individual mandate levies an exaction directly on uninsured citizens, or alternatively on their property not used for the purchase of health insurance. But it makes no attempt, of course, to apportion those taxes among the states by population. The enforcement penalty is not an income tax, excused from the apportionment requirement under the 16th Amendment. While the mechanics of the Act do in part turn on income, an income tax is levied on an accession to wealth, including gains, profits, and income derived. But the notion of a derivation of income is important to this discussion. Not only does the 16th Amendment refer to taxation of income from whatever source derived, but the Internal Revenue Code goes to that length as well. It tracks the text exactly of the Constitution. Thus, in order to tax income, as that term is used in the 16th Amendment and in the Internal Revenue Code, there must be an actual increase in wealth. Now, the Supreme Court has held in the past that in things like stock dividends, it's not things that are not actually cash, that are only theoretical wealth, even if they make the person who owns them feel some benefit, are not income derived and not taxable. In this way, the individual mandate is quite unlike Social Security taxes and Medicaid and Medicare taxes. These are taxes on what we think of as excises, on transactions or on employment, or even on the income of the individuals paying the tax. What we have in this situation is completely different in the sense that it does not revolve around whether a person is employed, whether a person engages in a business transaction, conveys property, or applies for and receives a license from the government. It applies to individuals because they are individuals. The imposition, if it is a tax, is an unconstitutional direct tax and capitation. With that, I'll close my opening statement. Thank you.
Thank you, Mr. Fisher. Mr. Cordray.
Thank you. And let me say, first of all, I'm thankful to have scared up a debate over the health care law. I've been seeking to have one all year with my opponent in the Attorney General's race, and he has declined every opportunity. So thank you for showing up to the basic state to talk about this with me. Let me start by noting a few things about the excellent presentation that Solicitor General Fisher just gave. And by the way, you and I are both founding fathers in a way. You're the first Solicitor General of Indiana. I was the first Solicitor General of Ohio. So we need to stick together. Let me first note that Tom did not argue that the new health care law violates the 10th Amendment, which originally was one of the two challenges that the states had put forward
in their lawsuit, and remains in the lawsuit, I believe, but I believe is utterly without merit, and I assume that's why Tom did not mention it here today. The argument about the 10th Amendment is that the new health care law somehow commandeers state governments, forcing them, constricting them to take actions against their will, which there's case law prints and other cases that does allow the finding of a 10th Amendment violation if a law does in fact have that effect of federal law upon the states. But the new health care law does not fall comfortably within that argument, because it does not in fact force the states to do anything. It makes significant changes to the Medicaid program, which has been the basis for the state's challenge on the 10th Amendment. But the Medicaid program is a voluntary program. In fact, for years, the state of Arizona did not participate in the Medicaid program. And then ultimately, they, like all the other states, have chosen to participate in it. Why? Because presumably they find the benefits of the program outweigh the burdens upon them, but they're free to disengage at any time. And the fact that the new health care law has changed the Medicaid requirements in various ways does not create a 10th Amendment problem. The other argument was that it requires states to form insurance exchanges, but the law in fact does not do that. It tells the states, form insurance exchanges, or if you fail to do so by a certain point in time, the federal government will step in and do that for you. So there's no 10th Amendment problem here, and I note that General Fisher did not claim that there was one, and that's half of the argument. The other argument really goes to the Commerce Clause. Does the new health care law fit within Commerce's broad power, as the U.S. Supreme Court for decades has defined it, broad power to regulate interstate commerce and articles of commerce among the states? I'm going to leave aside his argument about taxes and direct capitation. I don't think we need to get to those details in order to uphold the validity of this law. So let me talk about the Commerce Clause challenge. The first question he posed is, doesn't there have to be a limit on the power of the federal government? Well, there does have to be a limit on the power of the federal government, and we're agreed that there are limits on the power of the federal government. I will just say that as the Attorney General of Ohio, for the past 20 months, there have been numerous occasions where we have challenged, on behalf of the state of Ohio, the application or intervention of federal officials or authorities in various ways that we thought infringed upon our sovereign powers under our system of state government. In fact, we've been in the U.S. Supreme Court 3 times in the last 18 months, 2 of them in criminal cases, one of them that I argued personally, and one of them a revenue and taxation case where we felt that federal judges had unduly infringed upon the powers of the states and our state criminal justice system and tax and revenue system, and we have won all 3 of those cases at the U.S. Supreme Court. So we're not reluctant or reticent about asserting the powers of the states against the federal government. In fact, we have a lawsuit right now that is pending in federal district court in Chicago, where we're challenging the federal, the U.S. Army Corps of Engineers' power to act in the ways they have that we believe creates a public nuisance and potentially is going to allow Asian carp to enter the Great Lakes, which we think would potentially be a devastating impact on the Great Lakes. So when there is legitimate intrusion upon state authority, state interests, we will stand up vigorously to the federal government if we need to do so. Or if we can adjust things and resolve them within the political process, we will do that as well. And we do it all the time. That's what state attorneys general do. That's what state governments do. But is there a limit on federal government power? Well, we know there are limits because the U.S. Supreme Court, which is law of the land, has told us there are limits. There's the Lopez case and the Morrison case, which Tom discussed briefly, that do lay out some of the limits on the Commerce Clause power of the Congress. As he mentioned in Lopez, the mere possession of a gun in or near a school was found to fall outside of the Commerce Clause power of the Congress. Why? Because there was no economic activity of any kind involved. Had it been the sale of a gun, that would be different. Had it had to do with buying insurance against injuries caused by guns, or liability or other issues, that also would be different. But the mere possession of a gun, the court held, was beyond the realm of the Commerce Clause. And as Tom rightly pointed out, you could always make an argument. You can always make an argument. We're lawyers, you're law students. You always can make an argument that you could pile inference on inference and somehow claim that activity is economic. but the court held that the mere possession of something was not itself economic activity. Similarly, in Morrison, the Violence Against Women Act, and I think in some respects a closer case, it was found that what essentially was a justification for passing a criminal law at the federal level and liability for criminal acts was not itself economic activity. People can quarrel with those decisions, but whether you quarrel or not, that's the law of the land. So there are limits on congressional power. So the issue here is not the hypothetical issue of are there limits. The question is where is that line drawn, and does the regulation of the nation's healthcare system, which is acknowledged to impact 1/6 of the entire economy in the United States, does the regulation of that system and the manner in which that regulation unfolds under the Affordable Health Care Act, does that fall within the Commerce Clause power, the power to regulate interstate commerce that is very clearly given to Congress in Article 1 of the Constitution? And I believe that it does fall within that power for a number of reasons. First of all, insurance, the business of insurance itself is inherently an economic business. What is insurance about? It's about, are you going to pay for something now, or are you going to bear costs now? Or are you going to buy some sort of risk protection against contingent events in the future that may themselves have economic consequences for you and others? So what you're doing by definition when you make decisions about insurance is you're allocating costs now and in the future, and you're allocating risks, and you're making economic decisions about what to pay to whom, how much. And the whole business of insurance is an entirely economic business. It's an actuarial business. People are making judgments about economic impacts and economic risks. So let me just start with the whole concept that's at issue here, which is an insurance system. But healthcare itself is big business in this country. It is billions upon billions of dollars of care provided to people, not self-imposed care like a Christian Scientist might do in the privacy of their home, having nothing to do with the economic market, but it means going to doctors, it means going to clinics, it means going to hospitals, receiving services that are, in many cases, incredibly expensive. Have you seen an emergency room bill lately, or have you had anyone that you know in the hospital for surgery or there for overnight? Have you seen all of the aspects of those bills? It is a very heart and soul economic activity. And again, we're not talking about somebody putting a Band-Aid on themselves. We're talking about people purchasing extensive services at great cost throughout our economy. Then the question here is, if you're going to try to regulate insurance in a meaningful way, and Tom does not deny that health insurance can be regulated in a meaningful way. He denies that the federal government has any power to do it. So what he's in effect saying is the states can do it. You remember he mentioned early on that the states have essential and residual police powers that the federal government does not have. So what he's in effect saying is healthcare can be regulated, and the health insurance system can be policed by government in the United States. Begin with, but certainly, especially now, as you get close to state lines, if you're in Youngstown, Ohio, or Toledo, Ohio, or Cincinnati, Ohio, the notion that this is all some sort of intrastate market is not really consonant with the modern economy that we live in and the healthcare system within it. So the question is, where are you drawing the line about what Congress can regulate as an economic activity? And I would submit that this is well on the proper side of the line for Congress. Now, the rhetorical point that is made over and over again in the arguments against the bill is that if someone merely makes the decision not to purchase health care, they are making no economic decision at all, and therefore they can't be regulated by Congress and you know, who knows who else. But can't be regulated by Congress because they're choosing not to engage in economic activity. That is exactly the argument that was made in the Wicker case almost 80 years ago, and it's exactly the argument that was made in the Raich case, Gonzalez versus Raich, that Tom mentioned. In Wicker, the argument was that you were growing something on your property, You had no intention in engaging in any transaction with what you grew on your property. You were growing it solely for your own personal use. All right? No economic activity whatsoever. No buying, no selling, no transfer, no barter, no nothing. You grew something for your own use, you used it, end of story. And the argument was that was not an economic activity. The U.S. Supreme Court held that is economic activity. Why? Because growing and using something yourself may or may not itself be an economic activity in some technical sense. But when you aggregated all the potential impacts of lots of people growing things for their own use and withdrawing that all from a marketplace where otherwise it would be bought, sold, and bartered, the aggregate impact of that was large enough that it did impact economic activity. In fact, the phrase substantially affects interstate commerce and therefore could be regulated by Congress. That's been the law of the land now for 3/4 of a century. And it was reaffirmed recently in the Gonzalez versus Raich case, where the issue was if you were growing marijuana for your own personal medical use. Really the same issue as in the Wickard case, but you were not intending and would swear on your family Bible that you were never going to sell it. Questionable credibility for some of those people who might make that claim. Never going to sell it, never going to buy it, just going to grow it and use it yourself. All right? Not economic activity. Well, again, the court held on the basis of Wickard that you pile up all of the potential impact of many people doing the same thing, and it clearly had a substantial effect on interstate commerce. Now let's think about this healthcare decision. The notion is I'm merely choosing not to purchase healthcare. I'm making no economic decision. I'm having no economic activity. It is the exact same issue as in Wickard as in Raich, because what the impact of this is I choose not to purchase health insurance. Many others may make the same choice, not to purchase health insurance. What's the impact of that? All of a sudden in the United States of America, and this is the very problem Congress set out to fix, we have millions of Americans who have no health insurance. Some of them may be choosing not to purchase it because they feel healthy and think they'll never need it. Some of them are choosing not to purchase it because it's expensive and they're not sure they can afford it. And there's different subsidies and other provisions in this bill to try to make it affordable. We may not have gotten that right. We may have to adjust that in the future. But the ultimate aggregate impact of that is huge in terms of our health insurance system. When people have no health insurance and then they have a health problem, they don't stay outside the system. It is understood that if the problem is dire, they will get care. They may get it in an emergency room. They may get it at a doctor's office. They may get it because they fall unconscious on the streets and someone takes them there, whether they intended to go there or not, and thousands of dollars, tens of thousands may be spent to keep them alive. But that has an impact. Who do you think pays for that when they end up in the healthcare system having chosen initially not to buy health insurance? Well, you pay for it, and you pay for it, and I pay for it, and Tom pays for it, because it is the burden of uncompensated care. That is a significant economic impact. And so the notion that this does not substantially affect interstate commerce seems to be quite wrong. Let me just say also, and generically, the argument is one that any time Congress addresses an economic problem and tries to regulate a problem that substantially affects interstate commerce, and there's a free rider problem involved, that is someone free riding on the system, not paying their share, but expecting someday they will get the benefits of the system if it's needed. That's a common economic problem. Anytime that problem arises, the argument is Congress can't address it in a meaningful way. Only the states can address it, but not the United States Congress. That's fundamentally wrong, and I think it is a cramped and ahistorical and completely contrary to precedent reading of the Constitution of the United States and certainly the Supreme Court case law over the last 75 years. Thank you.
Thank you, Mr. Kruger. The speakers will now accept questions from the student panelists. Each panelist will have 10 minutes. We will begin with Mr. Ianetti.
Solicitor General Fisher. The Supreme Court has upheld laws that limit private rights but secure public interests, as long as the statute in question shall not be unreasonable and the means selected shall have substantial relation to the objective of the regulation. Proponents of the Affordable Care Act argue that citizens who presently refrain from purchasing health insurance drive up costs, and place an unfair burden on the insured. Mr. Fisher, shouldn't these citizens be required to give up some individual liberty to benefit the common good?
Well, the idea that everyone necessarily uses the healthcare system and therefore must pay for it, I think depends in part on what we already have in federal law in terms of how the healthcare system works. Now, Mr. Cordray mentioned that when someone is sick and they go to the emergency room, if they don't have insurance, he said it is understood that they will receive care. And indeed it is understood, because that's federal law. Federal law is set up so that hospitals must provide that care. Now we have the federal government saying, in order to pay for that, we're going to require everyone who is living in the United States to purchase health insurance, whether or not they want it, whether or not they're going to use it, and regardless of whether they personally have ever impacted the healthcare system. Now, the idea that we can hypothesize that chances are that people are going to engage in some sort of economic activity in the future, and therefore justify forcing them to pay for that in advance, I think it runs far wide of any precedent that we've ever seen from Congress or from the Supreme Court. Now, the question whether those who may ultimately use the system and maybe will impose costs on the system should be made to sacrifice some liberty is an interesting philosophical question. It's something that I suppose Madison and Hamilton and all the rest would have found difficult to tussle with. They decided that as a general rule, the way we are going to protect liberty is that we are going to require that Congress limit its authority to things like the Commerce power. That it's not a matter of deciding case by case, situation by situation, how much liberty is to be sacrificed for what common good. It's done by category. If Congress is regulating commerce, then it can enact the law. It doesn't matter the measure of liberty, aside, of course, from the Bill of Rights. If it's not a matter of commerce, then Congress has to keep its hands off. And let's consider also the implications of the theory that refusing to purchase healthcare insurance is itself an economic activity. I suppose by that line of reasoning, so is refusal to purchase, a health club membership. People who join health clubs, perhaps, we would think, are healthier, less likely to use the system, less likely to impose costs. Could they be required? Could everyone be required to join a health club and use it in order to keep health costs down? The same could go, I suppose, for purchase of automobiles. The United States government has a vested interest in the success of General Motors at this point. Could the Congress require all of us to buy GM cars because the failure to do so impacts the national economy? In that sense, everything is economic. There is no line to be drawn. And that's, I think, one of the reasons that it's quite obvious that this mandate goes too far in terms of trying to describe a regulation of economic activity. Thank you.
I just want to point out that the comment that's being made here, and I'm not sure I disagree with the comment, it's realistic, but if the notion was that everybody who refuses to buy health insurance is signing a lifelong commitment that they will never access the health system of this country in any way, that is, they're sort of declaring, they're sort of seceding from the United States for healthcare purposes. The same way we used to get cert petitions when I clerked at the Supreme Court from tax protesters who said, I have seceded from the United States of America. I should not be required to pay taxes because I don't recognize the authority and I don't accept the benefits, although I'm sure they were driving on the roads and engaging in all the other activities of normal life. So the notion that someone is choosing not to purchase health insurance, whether or not they've ever impacted the healthcare system, for most of us, that choice occurred before we even had it. If you were born in a hospital rather than at home, and if you're not a Christian Scientist and you receive medical services, you are impacting the healthcare system. And the notion that you're somehow going to commit yourself that in your old age you will never seek care to diminish your pain, to have surgery for any kind of need that you have, for any kind of injury that you suffer. It's a very antediluvian view of the world, and it's not a realistic view of the world in the 21st century for how we all interact with one another. And we all have liberty, but we live in a society where it's a system of ordered liberty, and we have to make some concessions with one another. And so the first issue here is this economic activity? I think it clearly is. The second issue is whether we have some inviolate spirit of liberty, that whether or not it's economic, we cannot be infringed. I mean, if that were true, then people could have resisted conscription and the draft, which is a drastic curtailment of their liberties, it seems to me. But it's justified because there's power given to Congress to do it. Here there's power given to Congress to regulate interstate commerce, and the notion that your liberty is infringed upon as you make these choices, as you're affected as part of the system, I think is just standard fare, frankly. So the other issue I would say is the argument's being made is kind of it's a ridicule by extreme, which is, well, if you can be forced to buy health insurance as part of the health insurance system, can't you be forced to buy a car or do anything else we want you to do? What's interesting is the same people who are interested in protecting the liberty of the citizens normally also give a certain deference and respect to the political processes of this country. We rely on the political processes of this country to be guided by a certain bit of common sense. We don't run to the courts in every instance to stop the political actors that we elect to office from making stupid decisions. The political process itself winnows out a lot of those stupid decisions. And the political process works. And if people dislike the Affordable Care Act, and many do, they should and will, I'm sure, continue to work in the political process to seek repeal of it, or modification of it, or improvement of it, and that's all entirely appropriate. The issue here is whether the courts should be used to block that political process in the name of some ephemeral liberty, and bar Congress from acting to address a very significant problem, and by extension, any significant problem where it's an economic issue involving free rider issues. Because the logic of the argument is that anytime there's a free rider problem, Congress can do nothing about it, because that's just people choosing not to make a decision. But it's a well-known economic phenomenon, and it is a part of this issue and many others.
Yes. Oh, thank you, Mr. Cordray. Next student panelist, please.
This question is for both Attorney General Cordray and Solicitor General Fisher, beginning with Mr. Fisher. Linda Greenhouse, the New York Times law columnist, recently wrote an article documenting Justice Anthony Kennedy's rightward shift over the course of his tenure on the Supreme Court, which is significant given that Justice Kennedy often casts the decisive swing vote in 5-4 decisions. Given that the holding in the Affordable Care Act likely will come down in a 5-4 split, is there any indication in Justice Kennedy's voting record as to how he may shape the court's final decision?
There's a great anecdote or sort of fun story about the Supreme Court that I'm sure Mr. Cordray is quite familiar with, and that is the story where when you're preparing for the U.S. Supreme Court and you're going to go up and argue your case, instead of saying, Mr. Chief Justice, and may it please the court, you should merely say, Justice Kennedy, may it please you. It's tempting to do. Oftentimes, he is the deciding vote. I can't claim to have tracked his record entirely on these things. I think, as in most cases, one reads his opinions and has a sense of restraint when it comes to federal power, but it's only a sense, and it's only at the vaguest level. So I can't cite you chapter and verse on what Anthony Kennedy has said. Perhaps Attorney General Cordray can. But I feel like that both positions have a fair shot with Justice Kennedy. I like our chances on our side, and I'm sure Attorney General Cordray likes his chances, and that's what makes all of this so much fun.
Well, I actually put for Justice Kennedy, but it was 20 years ago, so maybe my perceptions are not current. But first of all, I don't know that it's a given, people are taking as a given, that this case will end up at the U.S. Supreme Court in any of its manifestations. You know, we have a federal case brought in the federal court in Virginia. We have the case that we're for the most part referring to here, brought in federal court in Florida. There are also many other cases not brought by states, but brought by other individuals or groups around the country that have challenged this law, one in Michigan and in this circuit and a number of others. And there were similar challenges to other major pieces of legislation in the past, the Medicaid law, Medicare law, probably the Social Security law. They haven't researched that when they were enacted. It's not at all clear that this will reach the U.S. Supreme Court, and it's not at all clear that it will be a close call when it gets there. There tends to be this assumption that the court is so bitterly divided ideologically that inevitably you'll have 4 votes on one side and 4 votes on another side whenever Republicans and Democrats are disagreeing. But the court is a more subtle institution than that, and the fact that there are a lot of close constitutional cases that go 5-4 doesn't necessarily mean this will be one of them, or any will be one of them. And in fact, that was the perception of the Miranda case when it went back up to the U.S. Supreme Court, and they took a case to potentially overrule Miranda versus Arizona. And in the end, it was, I believe it was an 8-1 decision, with Chief Justice Rehnquist writing to uphold Miranda, even though he had criticized it in decisions for years. So depending on what happens in the lower courts, depending on how quickly these lawsuits proceed, there are various procedural obstacles to the suits that may or may not hinder them. There are ripeness issues, there are standing issues and other things, and some suits will proceed faster and some slower. It's no telling when it might actually get up through the federal courts of appeals, and whether the federal courts of appeals will disagree on it. If the federal courts of appeals act with unanimity on this, and there are several challenges that are rejected, I'm quite sure if the courts of appeals strike down the law, that will go to the Supreme Court. But if they uphold the law, it's not entirely clear that the U.S. Supreme Court will ever take up this case. I mean, it's a hot political case now because it was filed, I believe, in many cases, and I'm not impugning Tom or his state, but for many people this was filed for political reasons. It was a continuation of the political fight in the Congress. People who now are advocating joining in or not joining in, that's mostly grandstanding because it's an injunction action, so whatever happens will apply to the whole country. Whether other people are named on the pleadings at this point or not makes no material difference to the impact of the case. But I wouldn't assume that it necessarily will go to the Supreme Court. It will be a close call when it gets there. As for what Justice Kennedy will do, even though I clerked for him 20 years ago, I will just tell you that I would have no idea.
Next question, please.
Mr. Cordray, you might as well stay standing. Does the government's recent shift in the defense of the healthcare law, now focusing on the tax and necessary and proper clauses, signal that the Commerce Clause challenges have significant merit?
Yeah, I don't know that it signals that. I think that people talk about things, and when it goes through the Congress, Congress tends to make the assumption that it has authority to do anything it wants to do, and it's not necessarily correct, as the Lopez and Morrison decisions indicate. But the issue when the Justice Department lawyers, or state lawyers in our case, when we actually settle in to defend the constitutionality of the statute, which is of course our legal obligation in any case where a state statute is challenged, and it's the Justice Department's obligation in any case where a federal statute is challenged, you sort of sober up and you bring all your tools to the battle. So if there's an argument under the Commerce Clause, you're making that argument. If you think there may be an argument under taxation authority, you make that argument. If you think there's a general welfare argument, you make that argument. At the same time, you're making standing arguments, you're making ripeness arguments, you're making any argument that will win you a dismissal, whether or not it wins you some broader argument. So it doesn't surprise me that they would be defending on alternative grounds, and we do it frequently, and frankly we'll defend on any ground that we think is plausible. But I don't know that signals that it just wouldn't be a wise strategic approach in a case where a statute is challenged and you had 3 defenses to only raise one of them. I do think, for myself, and my analysis of the law has really focused on the Commerce Clause issue because I think it is sufficient and I think it is well-established law, and I had not really even looked at the direct tax or capitation issues because I don't think you need to reach those, but I can understand that lawyers engaged in a case seeking to defend a law will raise all the arguments they think might appeal to a court, because the reality is you never know what will be persuasive to one judge or another. And particularly, in cases at upper levels, Court of Appeals or Supreme Court, you may have an argument that you think is your best argument, but if that appeals to one judge and another argument might appeal to another judge, you may not have it. So that's my little strategic litigation tip for the day.
I think it does suggest a certain level of weakness, in part because the background of the law was such that the president, who is not only a lawyer but a constitutional law scholar, so definitively characterized this act as not an exercise of taxation authority. And I think those comments probably have more impact coming from a president of his distinguished background than from a president perhaps who was not a lawyer. And people took him seriously, and should have taken him seriously when he said that. And I think that an important distinction between what the federal government is doing now, the position where it finds itself, and what Attorney General Cordray and my boss and our office, what we do when we defend state laws, I think it's important to observe. The federal government has a unitary executive. If the President of the United States says this is not a tax, he can tell the Department of Justice not to defend this as a tax. Now, if a governor proposes legislation, advocates for legislation, and is successful on a particular theory, when there's a lawsuit about it, the Attorney General, who is separately elected, can and will take whatever position is in the Attorney General's best judgment. The Attorney General is not accountable to the governor. So I think the divided versus the unitary executive is a significant factor here. Another important aspect of this to consider is that in litigation, even if you've got many theoretical, plausible arguments in support of the position, oftentimes it is disadvantageous rhetorically to invoke more than you need. If your power, if your position on your lead argument is so crystal clear, then why are you bothering with the rest of it? So I think there's a tacit acknowledgement. I'm not suggesting the federal government knows its goose is cooked, but it's a tacit acknowledgement that there are some weaknesses with this position. And so, of course, it is bringing in all the field artillery it can muster in support of this act, which, of course, is the centerpiece of the Obama administration, at least up to this point.
Thank you, Mr. Fisher. The last question from the student panel.
This question is for Attorney General Cordray. Prior to signing the health care law, President Obama promised that it would cover abortion services. As a result, the women's rights community supported the bill. They were shocked when soon thereafter the President signed an executive order with the Hyde Amendment attached. This amendment bars all federal funding for any abortion services. The order has sparked unrest within the women's rights community and groups who contend that the President's use of the Hyde Amendment contradicts his record on abortion. Mr. Cordray, has the President retracted his promise?
I think that, with all respect, that question goes beyond the legal issues we're here to debate. For me to pass a judgment on whether the President kept or didn't keep the promise in enacting an executive order is not something that I know enough about to have a judgment about, and I'm not going to offer a judgment about it here. So I don't have a particular answer to that question.
Would you like to rebuttal? No.
Now with a 10-foot pole.
Well, I have a question for both panelists, actually. Well, a couple. First, when does the law go into effect? What year, technically?
Well, I think it depends on what you're talking about. The individual mandate.
The mandate itself.
Oh yeah, the individual mandate becomes fully enforceable in 2014.
Okay, so you're taking your case to court in 2010, but the law does not go into effect until 2014. So do the states have standing? Do they have true standing in this case?
True standing, yes.
Yes.
The federal government has made much of this, and both of the idea that the states don't have standing to be talking about the individual mandate, and that in any event this challenge is premature. the states are going to bear the brunt of what happens with this individual mandate, both in their Medicaid system and their insurance regulatory systems. And so I think there's sufficient direct injury, which is the term, the operative term, when we talk about standing in federal court. As for the timing, the rightness issue, it's certainly the case that where there is a hypothetical injury coming down the line that may not occur, that maybe there are sufficient conditions or several conditions that could go one way or the other, that oftentimes courts will say, you know what, your challenge is not right. We don't know that you're going to be injured. We don't know that the activity that you are complaining about is actually going to come to be. This is not one of those cases. This is a case where we know this law is going into effect in 2014, well, barring, of course, a political change, but that isn't the sort of contingent circumstance that would typically bar a challenge. An interesting way to think about this is that if we are not permitted, we being the states, are not permitted to bring this challenge at this point, when can we bring it? When does the challenge suddenly become right? Do we have to wait until 2014 until everything's a go? And all of a sudden run around and try to get an injunction the day that it's going to go into effect when we could have theoretically been trying to have an injunction in place all along? Maybe it's not 2014, maybe it's 2013.
But Mr. Fisher, excuse me, Mr. Fisher, has anyone been injured by this act now?
Well, we have what is known as a reasonable prospect of being injured, which is all you need. And I think Mr. Cordray would agree that we see all the time in the state government and the federal government too, what are called pre-enforcement challenges. A state legislature will enact a law that is controversial, that some individuals will be injured by, but it won't become enforceable until, typically maybe the middle of the year when all the new laws go into effect. Well, it is perfectly acceptable to bring what is called a pre-enforcement challenge to seek an injunction against that law, even though today it is not having an injurious effect. So the question is really only one of how much time is too much time, if at all. There's no contingency that we're waiting on except the expiration of time. And if we can't bring it now, when can we bring it? There's no obvious answer to that. But my point is only that it is a durational issue, not a contingency issue.
Mr. Cordray, would you like to respond to that?
I can feel Chief Justice Rehnquist shifting restlessly in his grave. For years, he and other conservative jurists have put forward doctrines of standing, mootness, rightness as obstacles to cases going forward, and this demonstrates it just depends on whose ox is being gored. With the shift, the kind of ideological shift or jurisprudential shift here for states that are advocating a very activist approach is demonstrated by the fact that they're sort of shooing away any and all procedural obstacles or hindrances to the fact that they can't sue today rather than a couple of years from now. In fact, Attorney General McCollum was so eager to sue, and Attorney General Constitutionality in Virginia, that they raced to the courthouse minutes after the law was signed, so they could, you would assume they really wanted to file to invalidate the law before it was signed and before it was law, because why should it become law if they can get their arguments heard by the court before that happens? So, I'm not steeped in all the procedural arguments here because that was not part of my assessment of the law. I was looking at it on its merits, but the notion that a reasonable prospect that I'll be harmed someday is the opposite of the sort of procedural position that state and federal lawyers typically take when the government is sued in cases and they're seeking to uphold the validity, the presumed validity of these laws. The other thing is that, in fact, the notion that the president made some statements and that somehow renders the law invalid or creates an estoppel that you can't make legal arguments in a court. In fact, the judicial approach to the constitutionality of laws in this country, at both federal and state levels, is laws are presumed to be valid unless they clearly infringe upon constitutional provisions or outside of constitutional authority. There's a heavy presumption of the validity of laws. Why is that? It's a respect that the courts pay to the political process. The courts are not dominating the process, they're merely enforcing the boundaries of the authority that's given in the Constitution. But here, it seems like all presumptions are being made in favor of bringing the suit, bringing it as fast as possible, shooing away any procedural obstacles, and striking down this law. And I think that it's entirely backwards of how Tom and I and government lawyers normally handle these types of lawsuits.
Thank you, Mr. Cordray and Mr. Fisher. Our speakers will now accept questions from the audience.
There might be a few.
Okay. Professor Adler, actually.
We obviously didn't put in place the rules for how to exercise this discretion.
Is Professor Adler here? My question is for Mr. Cordray. If the Supreme Court has recognized a fundamental constitutional right to refuse medical treatment, including life-saving medical treatment, how can the federal government, or perhaps for that matter any government, force someone to purchase insurance to provide for something that people have a fundamental constitutional right to refuse?
Well, that's an entirely different issue, it seems to me. And that's an issue of whether there is some sort of individual constitutional right that would be infringed here. That's not, if you're tracking this, the argument that's being made in this case. The argument being made here is whether Congress has the authority under Article 1, regardless of whether there was ever a Bill of Rights, and of course there was none initially in our Constitution, to even address this subject. Okay? The separate issue of whether someone has a constitutional right to refuse medical treatment, I think you're mixing apples and oranges with your question. I think someone has a constitutional right to refuse medical treatment, but there are many situations. This goes back to, I suppose, whether someone could secede successfully from our healthcare system and with enough clarity of intent and certainty of successful execution that we could say to them, you don't need to buy health insurance because you will never cost 1 cent in health care throughout your lifetime. And that's a different issue from the one you're raising. I think in any individual instance, someone would be free to refuse medical treatment, but there are many situations you can imagine where that wouldn't in fact be so, and that wouldn't really be their intent. They just don't want to pay for the insurance now, but later when they need medical treatment, they'll want medical treatment. And/or there are lots of situations where it may or may not be within their power to make a decision. Maybe they're in an auto accident and they are unconscious and they would immediately be taken to the hospital and they would be cared for, whether or not anyone knew that they had intended throughout their lifetime to never enter the healthcare system. So I don't see the two things as on all fours in any respect. Yes, be my reaction.
Are there any students first with questions?
My question is for Mr. Fisher. Mr. Cordray has advanced the argument that this mandate does not necessarily regulate the act of illness or the act of wellness, as you stated earlier, but the actual use of the healthcare system once that illness occurs. So, could you respond to that it's not actual, is it the behavior itself that's regulating, or are they regulating what that behavior causes them to do, and the impact financially on the system, and thus the implication of the Commerce Clause?
Well, manifestly, it is not the regulation of conduct. If that is in fact what Congress wanted to do, then it could quite easily say that you must purchase health insurance if you're going to do X or Y or Z. It didn't. It says you must purchase health insurance. That is as plain a regulation of inactivity as I think there is. And if we back our way out of that by saying, well, yes, but inactivity has economic consequences, again, I ask, where's the limit? Where do we draw the line if that is not a regulation of something other than economic activity? Now, your question reminds me that Attorney General Cordray mentioned things about somehow my position was implying that the federal government could not regulate the business of insurance, for example. Far from that. I do not advocate that at all. In fact, the only reason states are able to regulate the business of insurance is because of a federal act called the McCarran-Ferguson Act. I fully acknowledge that that act is subject to congressional alteration. But what we have here is not a regulation of the business of insurance. It is an imposition on individuals to buy a product.
Would you like to respond to that, Mr. Cordray?
Well, I don't think states need a federal law to tell them they can regulate insurance. I think they have that power under their police powers. The McCarran-Ferguson Act gives the states the authority to, it disclaims a federal intent to regulate insurance, but the states certainly have that power. But no, I don't think I have anything further to say on this at this point.
Next question, please. Someone from the front row.
My question is for Attorney General Cordray. I think this kind of goes with the last question, and I think you're responsible about the analogy you drew between this case and Wickard and Raich. But my question for you on this analogy is, in Wickard and Raich, there was a product that was being created, and that, in creating the product, in planting the marijuana or planting the corn, the court said those two individuals were entering into the market. Here, when an individual does not purchase health insurance, how has that individual entered the market? I think there's a hole in the analogy. I know we've talked about it.
Okay, sure. Well, in neither Wickard nor Raich does the individual enter the market. They conduct an activity, but they're not engaging in any economic activity. I do a lot of things. I do a lot of things. I worked out today. Okay, that in itself is not an economic activity. However, if I were to buy a health club membership or a gym membership to go work out, now it's an economic activity. Or if I were to buy shoes or other things to engage in that activity. So the mere growing of something is itself not an economic activity. It is an activity that, if engaged in the aggregate by many people, as opposed to going into the marketplace to buy and sell those products, will have a substantial impact on interstate commerce. That's what the court had held. But similarly, if I decide not to buy health insurance, and millions of other Americans also choose not to buy health insurance, in the aggregate, that's going to have a huge impact on the system, because millions of those people will find their way into the healthcare system at some point, costing a lot of money, and you will pay for it, and I will pay for it. How do we know that? Because that's the system we have now. It is an undeniable fact that there is an immense economic impact from the free riders who choose not to purchase health insurance for all the many reasons that they might make that choice. There are certain side products of our living in this society that create costs and other things. And the notion that we are these entirely independent individual agents, and again, I go back to the tax protesters who file on the U.S. Supreme Court on a daily basis, saying that they should not be obliged to pay taxes because they have determined that they themselves are an inviolate entity, have nothing to do with the United States of America. They seceded from the Union and exercised their God-given rights not to belong to this government or society, yet they're still living here. I mean, it's a misguided fantasy view of how they fit into our society. In my view, you may choose to disagree, but it seems to me there's immense economic impact from millions of Americans not purchasing health insurance and imposing all the costs of their health care on the rest of us, which we all absorb, and our premiums go up as a result.
If I could just...
1 minute.
Sure. Hey, I'll take it. I think that I'm reminded that I think the proper analogy, the proper way to compare Wickard with this situation, or Raich, I guess a lesser degree of certainty would be, this is as if the government came in and said to Mr. Wickard or Ms. Raich, you have to grow weed, you have to grow marijuana. We're going to make you do something that impacts, because you're refraining from participating in the market as having economic consequences. Think about, again, the GM car example. We don't buy enough GM cars, people get laid off. We end up paying more taxes for more unemployment insurance. there's a greater burden. There is an economic impact for any negative thing that you do in that sense. What we're looking for here is some positive activity, some actual activity, as opposed to an economic inference from an activity.
I think the student here.
The way I see the individual mandate is that you have to buy a private product, otherwise you'll face a penalty or fine. But, and I can agree with some of the arguments. You can regulate economic activity, but that when you engage in economic activity by buying the health insurance, but where does the authority come from? Do you cite a legal precedent that forces individuals to engage in economic activity?
I've actually cited one in a piece that I wrote on this, which is in the very first Congress, with many of the founding fathers who helped write the Constitution, there was a law that required everybody who would be part of any militia to purchase, and I don't remember the exact terminology now, gunpowder, shot, and other materials so that they could muster out and serve in the militia. So there was an explicit requirement by the Congress, in the first Congress, that individuals purchase a product for purposes that the Congress felt were important enough to impose that requirement. There's nothing unconstitutional about that. Did it infringe upon their liberty? Did it take money out of their pockets? Did it make them do something they might not otherwise have wanted to do? Yes, but that's not unconstitutional. If you can actually conscript people into service, the deprivation of liberty, similar to putting them in prison, confining them and their ability to do what they want with their life, and that's permissible if Congress is within its power. And here, I believe they're well within their commerce power. The mere fact that someone's having to purchase a product is not in and of itself beyond Congress's powers. So that's an example from the first Congress of the United States.
Rebuttal.
Congress also has the power to raise and support armies.
You're a student in the back. Okay. The one in the back. I promise we'll get to the two names.
With all due respect, Mr. Cordray, I just want to point out a fundamental flaw in your previous statement was if they chose to join the militia, they had to be forced to do that.
But they could also be required to join the militia by law. And therefore, you require them to join the militia, and then you require them to purchase products to do so. I mean, raise and support an army is one thing, and you can raise taxes and the government could self-finance it, but they actually require individuals to buy products in order to fulfill the purposes that Congress intended by federal law. So the mere notion, these things are getting mixed together in ways that fuzz them, but the argument is Congress can't force me to buy a product or service. That's false. They have done so. They did it from the very first Congress. The question is not, can they force you to do that? The question is, are they justified with the particular provision that they enact? Do they have a power to do that? But the mere buying of a product or service is not itself some violation of your individual liberty or violation of your constitutional rights. If it is subject to an orderly congressional scheme, which, by the way, the courts typically address and judge according to a rational basis review. Is this rational related to the objectives that Congress is trying to achieve? And that is a deferential standard of review, although it's a very different standard of review than Tom would like to apply here.
Well, adding on to that, Mr. Cordray, is this a legitimate end for the federal government?
That's correct. And the legitimate end here is regulating healthcare and interstate commerce. Correct.
Sorry, one student over here.
Solicitor General Fisher. The federal government has broad taxing and spending powers. You can, for instance, enforce a tax credit for buying double pane windows, having children, and buying GM cars. So if the government were to raise taxes slightly and offer, I think it was a $675 tax credit for buying insurance, it would be an economic mandate with the same force as the individual mandate currently in law. Would this be more or less constitutional, do you think?
I think it depends on the details of the tax you're talking about. If the tax is on individuals, it's a capitation and it's unconstitutional. If the tax is just an increase in the rate on income taxes, it's a different story. It's covered by the 16th Amendment. And I think credits and deductions, by the way, the Supreme Court is typically treated to be different from actual taxation. There are, I think, cases that say where Congress has levied a tax but has permitted a deduction for something that independently it could not tax. That's okay. That's a different kettle of fish entirely. So I think we have to flesh out the details. But I do think that it's legitimate to say, gosh, Congress could have gone about this and achieved something akin to this result, something very similar if it just merely forthrightly said, here's an increase in income taxes and here's the benefits, kind of like Medicaid, Medicare, Social Security is a slightly different model. But yes, you can do that. You can tax things, you can tax excises and incomes, and then have benefits. But that's not what Congress wanted to do. I think for relatively obvious political reasons, they wanted to go a slightly different route. And the question is, have they, in so doing, exceeded their authority? And obviously, I submit that they have.
By the way, I would just make the point that
Very quickly.
the issue's been raised, could they make you buy a GM car or something of that sort? Congress, for its entire history, has affected and in effect mandated various spending decisions by individuals. Every time they bar the import of certain goods, they're forcing you to buy a domestic produced car or whatever other good it is. So Congress has dramatic impacts on our spending decisions. They mandate that we do certain things. It may be within a range, and then there's the example I gave from the 1798 Congress, but for the first Congress, but they have all kinds of effects on your latitude to make spending decisions about buying or not buying products or services. They can bar you from buying certain services using the export-import tariff system and the like. So that's pretty commonplace.
Professor Enton, you have a question?
General Fisher, what if Congress had gone further in the statute and had simply enacted, say, a single-payer system of the sort that some advocates had proposed? Now, as you mentioned, the politics of that doesn't, but put that aside. As a constitutional matter, do you think that there is any conceivable system of single payer that would pass constitutional muster?
I certainly think we've got precedent for that. I mean, I think what we've got in terms of, again, of the current Medicaid and Medicare and Social Security today, those are something those are laws. You can tax and create a whole benefit system, and you can approach this problem that way. And I don't have any sort of prima facie argument against that. Now, I don't know what might happen in that circumstance, if there might otherwise be challenges, but that sounds like a completely different set of congressional authority and a different set of arguments. So that's the best I can do with that.
It's actually quite an interesting argument that's now become, isn't it? The real problem that Congress faced was it didn't go far enough. It should have imposed a much more onerous system. It should have raised various taxes. It should have imposed a single-payer system. It could do all those things, but it can't do the more modest healthcare reform that was enacted here, which in effect was the model that was proposed by Republicans in the 1990s as the counterweight to the Clinton plan at the time, which was closer to a single-payer system. So the argument now seems to be not that Congress went too far, but it didn't go as far as it could have, and it instead went sort of middling far, and that's somehow unconstitutionally broad. I just find it quite interesting.
We have two questions in the front two rows here.
Thank you. A question for Mr. Fisher and Mr. Cordray. Would the applicability of the necessary and proper clause be impacted by states' passage of state constitutional amendments, such as the Ohio Healthcare Freedom Amendment, which states that no citizen in the state should be compelled or taxed to purchase insurance or participate in the healthcare system?
I stood up probably prematurely. Mr. Attorney General, I would give you first crack at that. It's not. It's becoming quite common for states to pass similar kinds of laws. The Supremacy Clause, I think, resolves the idea that a state can somehow override what the federal government's done. But I think what it does is it presents a situation where there's a legally stated state policy And when there is federal government friction with that legally stated state policy, I think that in and of itself creates a whole set of interests that, I'm trying to speak as vaguely as I can, because I'm not thinking any state in particular or what its policies might be, but in any event, it certainly puts a state in a slightly different position in that regard. Now, I think it's important to bear in mind, though, when you are thinking about the supremacy clause, and when you're thinking about has Congress really, overridden the state policy, and have they done it properly? It's really not a matter of the degree to which Congress has infringed liberty. It's a question of how has it done it, and has it done it? Has it used the forms? Has it gone about it in the ways that the founders thought were appropriate? They did this for a reason. They divided and limited government for a reason, because the way that Congress has to go about exercising its power, such that it has enormous ramifications for the amount of freedoms we have left. So even if we measure what might happen in a single-payer system versus what we have now and say, boy, that would constrict a lot more freedom and be a lot more government intervention, it's a different set of authority, because the framers knew that to get to that level would require a sense of consensus and commitment that would be different at the Commerce Clause level. And the Commerce Clause, therefore, is limited to a smaller category of government intervention. So I think the Supremacy Clause question depends very much on whether Congress has gone about this the right way.
Well, I actually agree with what Tom said about the Supremacy Clause. And, there's various political statements people are trying to make by passing these laws at the state level. And there's a similar provision in Virginia law that's at issue in the Virginia federal case, and I noticed that the judge's initial ruling on motion to dismiss ducked that issue because there isn't much to be said. We had a nullification debate in the 19th century, and it led to the Civil War, and it's pretty much resolved. So I would essentially agree with Tom. Those are statements, and they matter, and they tell you what a state thinks. This is the age-old question: what do state officials do when they disagree with what the federal officials are doing? They can attempt to control their own delegations to the Congress and try to get them on the page that the state officials are on, and they can complain, and they can potentially try to go to court. But ultimately, the right place to resolve these issues is in the political process. And in the fullness of time, these issues may be revisited, and if a different majority has a different goal in mind, and for this working, or if there's convinced to be adamant opposition to it, this can come up tomorrow, next week, next month, next year in the political process. That's the place for these things to be fought out and adjudicated. And when people are upset that they lost in the political process, the right thing to do is regroup and pursue the political process. And that's, for the most part, the way things work in this country.
We have time for one more question.
I'm just concerned about the range of people who must purchase health care insurance. Suppose a person could show that if they purchased health care insurance that they could not purchase adequate food, clothing, and shelter. Would it be constitutional to make that person pay for health care insurance?
I don't think it's a constitutional issue there. I think it's a policy issue, and I think it's an implementation issue. The Congress attempted in this bill to make provisions such that if people were unable to buy insurance for lack of economic means, there would be subsidies and other provisions in place to address that. Did they get all that right? I'm not sure. We'll see over time. There may have to be adjustments, and it may be that they made errors. It's not impossible that Congress would make errors. They have been known to make errors in the past. But their intention was, I believe, to provide adjustments and credits and other things for not only for poor individuals, but for small business and others that might be unreasonably burdened by this. And it's an attempt to sort of share the load in that way. Whether they got it right, whether everything is as it should be, whether we'll have to go back and make adjustments over time, I would guess that we very likely will have to.
Any last comments, Mr. Bishop?
I think it would be fully consistent with my previous remark to say no, that would not be constitutional. given that I've suggested that even with all of the allowances for income level and subsidies, that it's still unconstitutional. But I think the point is, you know, it's a question of authority and the question of whether Congress is within its realm. It's not really a question of, on the individual side, what are their alternatives in that sense. It doesn't matter for our argument what the reason is that a person may not want to purchase health insurance, whether it's an income issue, whether it's an island all along kind of thought. What matters is that Congress has exceeded its authority, and that is what the founders said is to be worrisome when it comes to protecting liberty.
Thank you, Mr. Fisher. Thank you, Mr. Cordray, for your time. Mr. Griffith.
All right, ladies and gentlemen, we'd like to take a moment to thank our contributors. Please hold your applause to the end. First off, I'd like to thank, personally, please join me in thanking, special thanks to both the speakers, Mr. Richard Cordray and Mr. Thomas Fisher, also to the Office of the President and Provost, the Center for Policy Studies, the Office of Government Relations and Community Affairs, Kelvin Smith Library, the School of Law, our panelists, and also the entire undergraduate Constitution Day Committee. Thank you.